17th. If you haven't testified before this committee before, we do have a 2-minute rule on oral testimony, so a buzzer will go off, and please wrap it up at that point. First up today, we have SB 60 SD1 relating to victims of crime. This requires victims of crimes and surviving immediate family members to be notified of the right to participate in the restorative justice process. First, we have the Department of the Prosecuting Attorney, County of Maui. Looks like it's in opposition. Office of the Prosecuting Attorney, County of Kauai. Also in opposition. Community Alliance on Prisons. Afternoon.
Good afternoon, Chair Rhodes and Member Thielen. Kat Brady, testifying on behalf of Community Alliance on Prison. Always mindful that we have about 5,700 people incarcerated and almost 1,500 some odd people who are serving their sentences in Arizona, thousands of miles away from their loved ones, from their homes, and in most cases, from their ancestral lands. We are strongly in support of restorative justice, but we are confounded by this section that was added, 8, the part that's underlined. We don't understand why that's in there, because restorative justice is a voluntary process, and it's a process to give voice to the people who have been harmed, because most court cases, the victims their voices are not really heard, and they generally leave the court feeling unsatisfied. So restorative justice really gives them a chance to express the harm that was done to them and how they deal with that. And it has been a very successful process. We've been doing it, when I say we, Community Alliance on Prisons partnered with Hawaii Friends of Justice and Civic Education, and we've been doing restorative circles in the prison since 2005. And we have a 100% satisfaction rate. It has really been helpful because it helps people understand their behavior and the impacts that their behavior had on the people who they harmed. And I think that's the purpose of restorative justice. So when this section says about it, well, it's only offered to victims if there's no criminal charges, it seems like kind of bogus. I don't quite understand that. And I don't know if it's written in lawyer language, but it certainly didn't make a lot of sense to a person who's just a lay person and who cares about people and our community. So our request would be to remove section 8, the 8th bullet in this bill, and pass it without that, because restorative justice is something that really works. Thank you.
Thank you very much. Next up is Lauren Walker, in support. All right, I don't think we've completely solved all our technical problems from yesterday. Anyone else wish to testify in this measure? SB 60? Okay, seeing none, members, questions? Okay, member, any questions? Okay. Let's see here. Ms. Brady, if you're still, no, she just left. Okay, well, I guess there's no one to ask questions of anyway, so we will go ahead and move on. Moving on to HB 195. HB 195 relating to the Office of the Public Guardian prohibits the Office of the Public Guardian from petitioning for its own appointment as guardian of the person for an incapacitated person, and authorizes the court to allow the office to manage awards financial assets where no conservatorship is in effect. Okay. First, we have Judiciary, State of Hawaii, Moira Chen, Office of the Public Guardian. Probably butchered your name, too. It's just not going well today. What can you say? Myra Chen.
Moira, yes.
Afternoon.
Good afternoon, Chair Rhodes and Representative Thielen. Thank you for scheduling House Bill 195 today for hearing. My name is Moira Chen. I'm the Director for the State Office of the Public Guardian. This bill today is twofold. The first part is to prohibit OPG from petitioning for itself as guardian of an incapacitated person. This practice has been, or this non-practice has been going on for approximately 10 years. And we feel that we need to divert all of our energies and attention to being guardians of an incapacitated person. The second portion of this bill is to permit the court, in the absence of a conservator, to authorize OPG's access to financial information from banks and financial institutions, and to permit OPG to transact.
Sorry, these mics are kind of sensitive since we are on TV today. Yes, thank you.
And it permits OPG to transact finances on behalf of our clients. This is needed because banks and financial institutions need to know that we have statutory authority in addition to the court's order for OPG to act in these financial matters. Please let me give you an example of what we do, which will help us do our duties in these matters of finances. Many petitions for OPG guardianship is petitioned by the Adult Protective Services from the State Department of Human Services. Many of these incapacitated adults are elderly, isolated from family and friends, and in situations of self-neglect, financial exploitation, and sometimes physical abuse. When OPG is identified as the last resort and appointed as the individual's guardian of the person, the need to access client finances and the individual for clients' care and health services are foremost, as OPG funding is not used to pay for client care. Many of these cases are already in crisis, and it becomes critical in the absence of a conservator for OPG to act in matters of finances. We need to know what's in the bank, what they have available, and what we can use to pay for the immediate care and health needs.
Okay. Thank you very much. Let's see. I'll try to figure out who's next here.
Thank you. Good job.
Director McManaman, Department of Human Services, or her designee.
Good afternoon, Chair Rhodes, Member Thielen. My name is Elliot Cano, Adult Protective Services and Community Branch. I'm representing Department of Human Services Director Patricia McManaman. I'd like to offer our support to this bill as we both serve the vulnerable population by allowing the Office of the Public Guardian to access and pay the financial obligations of our vulnerable adults in a timely manner would be very beneficial to their care.
Okay.
Yep.
Thank you very much. That's all the written testimony I am able to access. If there's anyone else who would like to testify in HB 195. Okay. Representative Thielen, any questions? Okay. Ms. Chen, would you mind coming back up? Sorry to cut you off. We probably were going to answer all my questions in the remainder of your testimony, but let me ask a couple of things here. We were, well, I shouldn't say we because it was really me. I was trying to determine what the difference between a guardianship and a conservatorship is. Are they, I read the Black's Law definition, and I still don't really quite understand the difference. They seem very similar. So can you enlighten us on that topic?
In Hawaii, a guardian of the person deals with the client's health, welfare, education, and welfare. A conservator deals with property and real estate matters only.
Okay, that makes sense. So, all right. So they basically they don't overlap, and if you only have one or the other, the whole situation is not covered, is what you're.
OPG can do some financial matters, but when there's real property and large estates, we do not manage that kind of large estates or real property.
Okay.
And if OPG finds that, we will petition the court to get a conservator for the client if one is needed.
Who usually serves as conservator? Is it a financial institution or is it individuals?
There are some financial institutions, private entities, nonprofit institutions that are available if they're willing to serve for a particular client. They have the option to accept or not accept the conservatorship.
Okay. Okay, that answers that. But now, my understanding is under current law, HRS 565-403, a guardian, they can be rolled into one. The conservator can be the guardian together at the same time?
Yes, but in our situation, OPG is prohibited from serving as a conservator in addition to being guardians of the person.
Okay.
OPG as an entity, that is.
And in this bill, you're asking not to be able to name yourself as a guardian. So, but
Yes.
somebody else can still request that you become a guardian, correct?
Yes, a third party is.
Who usually does that?
A lot of the petitions come from Adult Protective Services,
Mm-hmm.
and an equal portion comes from acute care facilities, petitioned by private attorneys when a guardian is needed to assist the patient with no families in medical decisions and in discharge planning purposes.
Okay. Now, if the other portion of the bill was that it would allow your office to control some of the assets of some of the financial aspects of the incapacitated person. What would happen? It's not clear to me from the language of the bill now what would happen if a conservator is named later. Would your authority end, or is there some kind of concurrent jurisdiction over the assets between your office and a conservatorship?
We usually work closely with the conservator, and eventually we transfer all assets or all finances and monies that we hold in our possession to the conservator.
But under the language of this bill, you're not required to. So, I mean, I guess I'm a little unclear as what the lines of authority would be for the person's money, because we would be giving you some authority over.
Primarily, Chair Rhodes, is that we are asking for initial access to these financial institutions and banks, so we know what is there. When we know what is there, then we will know whether we need a conservator or not. In many instances, these individuals are incapacitated, and the banks will then stop communications with anyone trying to access the client's resources.
But if a conservatorship is named, then you have no problem. You're not. How's the way to phrase this? If we were to amend it so that it was clear that once a conservator was named, that you would no longer have any access to the financial.
Then we would defer to the conservator. If a conservator was already in place, then we would not have this problem.
Right. Okay. I understood that. I was just curious what happened if you had taken control of the finances and then a conservator was named. Would you still have any authority? And it's unclear to me from the language of the bill how that would work. But if you're okay with amending it to say, once a conservator's named, we don't expect to have access to the money.
Right.
Okay. So in terms of the a conservator's financial powers and the financial authority that the bill would be granting to you as guardian, what are they different? Are your financial powers over the incapacitated person's finances less than what a conservator's would be, or are they the same?
It's a little less because we would not manage real estate properties.
Okay. Okay. All right, so that sort of leads to the next question, which is, so the power the public guardian would have to, quote, transact business or take necessary action as to the above accounts. What does that mean? What all can you do? I mean, that language seems pretty inclusive. I just was wondering.
As the example I was earlier giving you, when a client is appointed or we are appointed over a client, the first thing to do is we contact source of income, usually Social Security. We find out where the monies are being deposited, and then we will then visit that bank find out what's in the bank and get a statement. The banks without this authority won't even give us a statement of the client's resources. We don't know what's in the bank, we don't know what's coming in, what bills are being paid, and this is how we start tracking how to take over the expenses and care of the client.
But you would anticipate if this bill passes that you'd be able to pay the person's bills, at least as regard to their non-real
Yes.
property?
Yes.
Okay. Okay. Okay, that's all I have. Any other questions from members? Just missing anything? Okay. Okay. All right. That's it. Thanks very much. All right. Moving on to HB 255 relating to public safety. This would establish a 3-year medical or compassionate release pilot program for certain ill, disabled, or geriatric inmates who are at low risk to public safety. First up for 255, we have Bert Matsuoka, Hawaii Paroling Authority, or his designee. Afternoon.
Good afternoon, Chair Rhodes and members of the committee. I'm Tommy Johnson, the administrator for the Hawaii Paroling Authority. Chair Matsuoka apologizes he couldn't be here today. They're holding hearings in Maui, and he's on his way back now. The Paroling Authority, we support the intent of this measure. We also agree with the concerns listed in public safety testimony in that it creates more bureaucracy that's not needed. In addition, the Hawaii Paroling Authority is a decision-making entity in the process and feels uncomfortable about being involved in the application process as called for in this measure, where an inmate could send an application to the Hawaii Paroling Authority. We have amended, we have drafted proposed amendments to our administrative rules to broaden the language to allow more offenders to be considered for compassionate release. In addition, and I'm paraphrasing my testimony here, all of the applications that have been sent to HPA from 1 January 2011 through 31 December 2013 that qualified for consideration were approved, subsequently released, and we have 2 applications currently pending today. Subject to your questions, that's all I have.
Okay, thanks very much. Next up, we have Director Sakai, Department of Public Safety. Afternoon.
Chair Rhodes and members of the committee, you have our written testimony. With your permission, I'll just summarize.
Please.
Hopefully finish before the buzzer goes off. We support the intent of this bill, but we submit that it may not be necessary. We substantially do whatever is called for in the bill. The process is there. We have been looking at it closely, and we are tweaking the process to make it a little more efficient. If you choose to go forward with the bill, though, we'd like to point out a couple of concerns with the language in this bill, and they're found on page 2. The first has to do with the inmate-generated requests. Under this bill, if an inmate generates a request, I will have 20 days to turn around and make a recommendation, but basically that's simply too short a time. Generally, if an inmate is in a condition such that he meets the criteria, he or she meets the criteria spelled out in this bill, our doctors will know about it and will, in all probability, will have already processed the request. If the inmate doesn't meet the criteria spelled out in the bill, I would have to then have our doctors take another look. And this would increase the workload. The second concern has to do with Section P, which requires us to adopt administrative rules pursuant to Chapter 91. This calls for a pilot project, and I really don't see the need for us to adopt administrative rules for a pilot project. In fact, if we did this, then we would have to slow the process down and go through the entire public hearing process, check with all the myriad other state departments to make sure our rules are aligned before we can get the program launched. And the program already exists. So with those comments, I'll stand by for any questions that you may have.
Thank you very much.
Thank you.
Next, we have Richard Minatoya, Department of the Prosecuting Attorney for Maui. In opposition, next we have Gary Yabuta, Police Department, County of Maui. Also in opposition. Next is the Office of the Prosecuting Attorney for Kauai. In support? No? In opposition? There's conflicting. Take your pick. It's either in opposition or support. Next we have Community Alliance on Prisons. And it says you're in opposition too, which I believe is actually correct, so that's good.
Good afternoon, Chair Rhodes and members of the committee. Kat Brady testifying on behalf of Community Alliance on Prisons. Always mindful that we have more than 5,700 people in prison and more than 1,500 serving their sentences thousands of miles from home, their loved ones, and in most cases from their ancestral lands. We are strongly in support of compassionate release. We have no idea why it would have to be a pilot program. I sit on the Institutional Review Board at UH. I know what a pilot program is. This is an existing program. It's just broken. So we're asking that you fix the program, not pilot something that all over the country people are finding that people are dying in prison. The cost of health care is skyrocketed. This bill includes releasing elderly people. This is just a graph from the Pew Foundation of the number of people, elderly people in prison, and it's risen by 282%. I mean, it's outrageous, and health care costs are bankrupting everything. So they have an infirmary at Halava. They also have a medical unit. And, you know, when you think about a medical unit, you kind of think it would be like a hospital. Well, it isn't. It's a prison with people who are really elderly, drooling. They can't feed themselves. They can't walk. They can't get out of bed. They need constant care. How would they be a threat to the community if they were on parole? They can't even get out of bed. And there are too many people who are dying in prison who their families would like them to spend their final years with them at home. If they present no risk to public safety or little risk, actually the percentage is about 2% recidivism rate for elderly people who are released, then what are we doing? Why are we incarcerating people at these outrageous costs? And we know it costs $127 a day in Hawaii to incarcerate somebody, and when you add the health care costs, it's huge.
Thank you very much.
Thank you. Be compassionate. Next
is Lauren Walker in support, it looks like. Next is Robert Merce, sorry. Afternoon.
Good afternoon. Chairman, members of the committee, my name is Bob Merce. I'm a retired attorney, and I've represented with other attorneys several inmates who have applied for compassionate release. I've heard Ted Sakai's general testimony that everything's okay. Let me give you an example of a case that I handled at this time last year. The inmate was in Saguaro. He called me from there. He said he had a terminal diagnosis, was being brought back to Hawaii. He arrived here on January the 15th. I went out to see him a couple of days later. He'd already been to Queens Hospital emergency room once within the first couple of days he came back. He was sitting in a wheelchair. I could barely understand him. I could barely hear him. He still had the tag around his wrist from the hospital, and he had trouble speaking and making himself clear to me, and it was absolutely clear. He had end-stage liver disease, and he was going to die. I told him I would help him. The next day I went back to the prison and I looked at his medical records, and I want to share with you one of the things I found while he was in Arizona. This was about a month before he came back. He had talked to the people in Arizona, and he asked the nurse if he could get help with compassionate release. And here's what the nurse told him, because she documented it in his chart, and this is a direct quote. Informed inmate, we cannot initiate compassionate release here at Saguaro. Advised inmate to contact mainland branch for what steps to take for this, end quote. So here's a dying man. He's in prison. He wants help. And what did the authorities do? They tell him, you're on your own. He also said he was cold and wanted a blanket. And here's what the nurse said. This is our prison system, your prison system, my prison system. The nurse said, I told him the request for an extra blanket is denied. There's no medical indication for this. He states he gets cold. I told him he had an opportunity at least 3 times in the last year to purchase an extra blanket. during special commissary, and he chose not to do so. So he didn't get an extra blanket. So he didn't get any help with compassionate release or an extra blanket, and he's dying in prison. He came back here. I started to help him.
Okay. Thank you very much.
You're welcome.
Next is Lillian Ulani Harwood Wakine Kona. Afternoon.
Good afternoon, Chair Rhodes and members of the representatives here. I would like to share my reason for supporting HB 255. My husband was incarcerated for 41 years. During his incarceration, he contracted hepatitis C, for which he received a modicum of medical coverage. At one point, his illness took a turn for the worse, and the prognosis was terminal. He was given 1 to 4 weeks to live. Our courageous attorney, who you just heard from, began the journey through the valley of bureaucracy, and it took 6 months for the transition to take place. Bearing in mind that the illness is not being treated except for narcotics to ease his pain, and it is debilitating. Should we have not been so persistent in our efforts to get a compassionate release approved by the paroling authority, my husband would have died without dignity. The process as it stands requires assurance that an inmate will die within a prescribed amount of time. And I have a little comment in there. The last time I looked, I didn't have an expiration date on my forehead, so that's hard to determine. But when I look at the present bill, it also wants assurance that the applicant would not commit a crime once released. And is that the same requirement that we ask of healthy inmates seeking parole? My husband was given an excellent medical and naturopathic care once he was released, able to repair broken relationships with his children, bury a son that he never met who was adopted out once he went to prison. And because of this compassionate parole, my husband, Delbert Wakine Kona, was given 27 months additional to the 1 to 4 weeks that had earlier been diagnosed. It was giving him time to face death with quiet courage, strength, and integrity. My greatest concern is that your idea of the pilot program is not a good one. Delbert passed away, by the way, last week. Thank you.
Sorry to hear that. Thank you. That's all the written testimony I have indicated here. Anyone else wishing to testify on HB 255? Okay, seeing none. Members, questions? Representative Thielen.
Thank you. Director, if you could come back up, and paroling authority, please. I have a couple of questions. Okay. What about the victim being notified that this release is going to take place? There's nothing in the bill that says anything about that.
It's not necessary because we are required to notify victims in any release of any kind.
We finally got that through, right?
It's been in place, and we have a relationship with the various prosecuting attorneys' offices, and the notification is done through them.
So it wouldn't be necessary to put it into the...
Necessary.
Okay. The other thing, I see this being driven by cost of incarceration. And we're talking in here that there can be some very serious offenders that would develop medical issues and then ask to be released. And then you are talking about the cost of, I'm sorry, not you, but the bill is talking about the cost of keeping them in prison. What is the cost to society when someone is released, has the medical needs and concerns, and it could be very iffy if that person is going to be released into a family home or any place of that sort, and if the person's released into a family home, there's no guarantee that that family will keep the person there. So are we creating a different form of homeless people on the street that have been incarcerated and now are going to be released and ultimately find themselves in a homeless situation and while being quite ill.
I think these are good points. I think there's a number of things that we as public officials need to consider before our department makes a recommendation for release to the paroling authority and before paroling authority actually makes the decision. Risk of reoffense, length of sentence, the
of incarceration. And I don't know as though this, I mean, you can do this anyway, right, in the paroling authority?
We already do this in the paroling authority, so we don't believe the pilot project is
I mean,
necessary.
someone comes to you and requests a humanitarian release. There's nothing that would prevent you unless there's even with mandatory minimum amounts for violent offenders, you still can carve off the length of time that those people serve.
We can't, the paroling authority has no jurisdiction to reduce a minimum sentence when a person's serving life without the possibility of parole or they're serving any portion of a court-ordered mandatory minimum sentence.
Okay, so if we're talking life without the possibility of parole, what kind of a crime are you talking about?
Those are normally murder cases, murder in the first degree.
Yeah, we had a case recently, Representative, where a family had called us and they requested a compassionate release, but unfortunately the inmate was serving a life without, and so we advised the family that you would have to petition the governor to get a commutation before.
So there's a method.
Pardon me?
There's a method.
There is a method. A method's in place.
Right now, I mean, within the law.
Yes.
Because we have got such a serious homeless crisis in this state. And then if we're going to release people that have, it's pretty clear that they've committed rather violent crimes, even though it's saying in the bill there's one sentence, well, they're not going to be likely to do it again. But I just think it's being naive to think they're going to go trotting off to a loving home, and that loving home is going to stay loving for this individual. And it doesn't, I don't see adding incarcerated prisoners with mental health and physical health issues to the homeless population that we have now.
Yeah, your points are well taken, and I.
We don't need it though, do we, Ted?
We don't need the bill to make the process. The process already exists. We're able to do it.
Okay. That's what I thought, that we just really don't need it. Okay. Thank you.
Members, any other questions? Okay, let's see. Yeah, if you guys don't mind staying there, that would be terrific. Well, the testimony from a number of people was that the population of the population in prison, the age of your prison population is aging rapidly, and it does seem to me that I don't know. Do you have statistics on how old prisoners are at this point?
No, we haven't been able to compile that. But let me just say that in prison, age comes early. Like a 50-year-old inmate is old because they come, life on the streets.
So back to the original question. So
Yeah.
you don't know how old you must know how old the prisoners are.
We know how old each inmate is.
You
but
haven't
we
tried
just
to
have
figure out what how many are above 70, how many are above 60, how many above 50?
Yeah, we don't have that. I don't have that right offhand.
Is it something you can get?
Sure, we can get that.
Okay, I appreciate that because it seems to me like, I think the statistics on older people committing crimes also indicate that not very many old people commit crimes, and obviously ones who are incapacitated physically somehow aren't going to be able, just by definition, aren't going to be able to commit physical crimes anyway. They might still be able to commit some kind of
We'll get
fraud or something.
Yeah, we'll get the numbers for you.
Okay, thank you. Now, at medicals, how many medical staff positions are there in DPS? I'm just down here in Hawaii, not the ones in Saguaro.
I'm going to ask Wes Munn, who's our medical director,
Okay.
healthcare director, to come on.
Yes, good afternoon, Chair, Vice
Afternoon.
Chair. We approximately have 3.5 FTEs of primary care physician staffing.
For the whole system?
Yes.
So that how many inmates do you have total in the islands?
3,800. It varies between 3,500 to 4,000 on any given day.
Okay, well, so that's 1 per 1,000 basically. Yeah, I don't have any idea whether that's a good ratio or not. Is that do you have vacant positions right now?
We have one vacant.
One vacant. Is it adequate to handle the load?
Present load, I would say we're adequately handling it. If we have additional administrative duties, then patient care will suffer.
Okay. Okay, so let me ask you, Mr. Johnson, at the HAR hearings, are outside medical opinions taken are other doctors allowed to examine the patient and then make their opinions known to the board?
I believe other doctors are allowed to make a recommendation, but it'll come with the packet with the primary care physician's recommendation, which is the Department of Public Safety's doctor.
So the DPS doctor would be the one that would bring in a specialist if they thought one was necessary, if they couldn't diagnose the illness for some reason?
Correct.
How often does that happen?
We have a fair amount of outside referrals to subspecialty care.
Fair amount meaning?
I have numbers, but there are issues that go beyond the capability of the primary care physician, rheumatology, orthopedics, allergy, etc., that we send out on a regular basis to community specialists.
Okay.
Oncology is one that's pretty big now.
I think the paroling authority, in your testimony, you said that you would be concerned having someone other than a DPS doctor making a recommendation for compassionate release. What's your concern there?
Well, that's not in our testimony, but I think we would be concerned if the inmate were to be able to send us an application directly, which would waste time. We would need to send that directly back to public safety to get the physician's input before the parole board could review the case.
I'm sorry. Let me read you the testimony that I'm talking about. The HPA is not comfortable with the possibility of involvement in the request application process outside a request from the PSD director where proper screening has been completed.
Right. So that would be inmates that applications that would be forwarded to us directly from the inmate. We would send back to public safety because we would need the primary care physician's recommendation. In the case of a specialty care doctor, we would need that as well attached to the packet. So if the inmate's allowed to send it directly to us, it's really wasting time it should be initiated by the Department of Public Safety's primary.
So in other words, you're not going to take into consideration, what the paroling authority's position is, that they will not listen to any other doctor other than the ones that work for PSD?
No, that's not what I'm saying. I'm saying that the packet should come from Public Safety to the director, and if there is a doctor, a specialty doctor that puts a recommendation on the packet, that should be reviewed by Public Safety's medical director before it comes to.
I guess I'm just not quite sure why an outside doctor's opinion about the medical circumstance of an inmate would be any less valid if it comes from an outside doctor, especially if you're relying on outside doctors for many of the diagnoses anyway.
But they would put the outside doctor's recommendation with the information from the primary care physician, and both things would be forwarded up to us, to HPA.
Okay.
The outside doctors we refer to are our contractors, so in this context, it would be our doctors anyway.
But my understanding from this bill is that somebody else could make the request, which presumes that there'd be an opportunity for them to examine the patient.
Right. And our concern...
I'm sorry, I pull over another mic.
Our concern with that is that the way the bill reads is that the request would be made to the paroling authority. The paroling authority would kick the request to us, and then we would have 20 days to get a final recommendation to the paroling authority. And I think
what I'm suggesting is, why couldn't it just... What's the problem with just having a second opinion, basically, and having the inmate be examined by another doctor that's independent of the system, and if they say, hey, you know what, this person has liver cancer, they're going to die in 6 weeks, then why shouldn't the paroling authority be able to look at that independently of what you send them?
Chair, basically, whatever recommendations from the outside specialists that we receive are already incorporated in the primary care's recommendation.
I'm suggesting that it's to do two separate tracks. One is that, yes, you can do it internally, and it sounds to me like you do it once in a while. The fact that it's like 100% acceptance rate makes me think that there must be more people out there. I mean, you'd expect there to be a refusal once in a while if you were letting everybody out that you should be letting out. The 100% of anything always raises red flags in my mind. Unless 100% of the people are voting for me.
It's 100% of the applications that qualified for release were reviewed and released. The HPA did reject some applications because they did not qualify.
I'm sorry, the paroling authority rejected, or the PSD rejected?
PSD may have rejected some internally for internal public safety reasons. Some requests came to HPA, and some of the requests that came to us did not qualify for one of three reasons. One would have been the person serving life without parole. The second would be the person serving a mandatory minimum sentence, which we don't have jurisdiction in the case. The third would be that the minimum sentence already expired, and the request would have been a request for an early parole hearing and not a compassionate release.
Okay. But coming back to the previous question, I guess I'm a little... why is it a problem to have a second set of eyes look at the same patient and have an independent pathway to the Hawaii paroling authority?
It's not particularly a problem, except the way it is written, because it places a real time constraint. To be real honest with you, because by law we are responsible for the care and custody of every individual. If there's an independent request, I think as a responsible public official, I would have to have our doctors check it out.
Okay.
And we would provide the second opinion. And what I'm saying is, in this circumstance, 20 days may not be enough time.
But at this point, you do allow outside, if the family requests a doctor look at the inmate, you'll allow that?
There's a mechanism for that, but the family would have to be responsible for the bills. For
the bill. Okay. All right. Members, any other questions? Okay. Seeing none. Thank you very much. Let's go ahead and move on to. What time is it? 2:45. All right. To members, there's nothing I'm prepared to make a recommendation on today, so there will be no votes today, period. So we'll roll everything over till next week, so just so you know. Okay, moving on to HB 272 relating to workplace practices, makes abusive conduct a public, makes abusive conduct in the public employment setting a workplace safety and health violation. First up, we have Barbara Krieg, Department of Human Resource Development. Afternoon.
Chair Rhodes, members of the committee. The Department of Human Resources Development, DHRD, is responsible for state executive branch employees. So employees in the state executive branch departments, we are not responsible for Department of Education. We are not responsible for University of Hawaii Board of Regents appointees. We are not responsible for Hawaii Health Systems Corporation employees. We are also not responsible for employees of the Judiciary or for employees of the counties. DHRD does oppose this bill for a number of reasons. They're in the written testimony. I'll just briefly touch on what those reasons are. The first one is that in general, it's very hard to define what workplace abuse is. This bill is no different in that respect. It's just hard to determine what would be covered by the bill, if not in the definition, then in the enforcement. The enforcement structure set out in the bill is, from our point of view, very flawed, in large part because, as I just mentioned, we do not have responsibility or jurisdiction for many, many public employees who would be covered by the bill, and the bill would make DHRD responsible for enforcing this law with respect to those employees. We simply don't have that authority. The other big concern we have with the enforcement scheme is that DHRD does not have the resources that are identified in the bill to handle the enforcement scheme. We do not have any investigators, and yet the bill requires DHRD to investigate all complaints. We do not have any hearings officers. We have a total of 96 authorized positions, none of which deal with either investigation or hearings responsibilities. We do not have resources for any staffing in terms of educational materials, serving complaints, or taking in those sorts of complaints. Also, as outlined in the written testimony, our concern with the bill is that it does present conflict with existing workers' compensation law, and we believe it presents conflicts with DHRD because we administer for this state executive branch department employees the workers' compensation claims, and there are elements of this law that could conceivably put us in conflict with the processing of workers' compensation claims. So, mindful of the 2-minute warning, just in summing up, most employees are treated very fairly. If the legislature is inclined to give resources to a bill of this nature, we'd rather have the resources to do education and support for the employees.
Thanks very much. Next up is Director Takamine, Department of Labor and Industrial Relations, or his designee. Afternoon.
Good afternoon, Chair Rhodes and honorable members of the committee. I'm Jade Butay from the Department of Labor and Industrial Relations. We stand on our submitted written testimony opposing this measure. I'll just briefly note that making abusive conduct as a workplace safety and health violation would be extremely difficult, if not impossible, to enforce. And as such, we recommend that such a standard not be established. And secondly, Hawaii workers' compensation law already allows workers to file claims for emotional distress. Thank you.
Okay, thank you. Next up, we have Randy Pereira, Hawaii Government Employees Association, in support. Next, we have Carol Kubo.
Ryan Kobayashi. I'm from City of County Department of Human Resources. We stand on our testimony as submitted. Sorry. We support the intent, but we have the same concerns as DHRD.
Support intent. Okay. That's all the written testimony I have on HB 272. Anyone else wish to testify on HB 272?
Yes, I believe we did submit written testimony. I don't know why we haven't got it.
We might have. I may just not be able to access it from here. Sorry. Please proceed.
Right. I'm Deputy Attorney General Jim Halverson. I'm the supervising deputy of the Employment Law Division. The Department of the Attorney General also opposes this bill. I'll make sure we get the written testimony to you, but we certainly support the points made by Director Krieg in her testimony for Department of Human Resources Development. We also bring a little bit of historical perspective to this. I was involved in the civil service reform effort in 2000 and 2002. In fact, I was the deputy director of the Department of Human Resources Development during that 2-year period. And during civil service reform, we were making a big effort to try to clearly establish the jurisdictional lines for employees and for unions to get recourse for their complaints. Because what we were experiencing, what the biggest complaint by employers at the time was, we would have an employee or a union file a complaint with workers' comp, a grievance, an appeal with the Civil Service Commission, and a lawsuit. And we tried to get this thing back under control where we weren't wasting a lot of resources fighting the same issue on multiple fronts. And we are concerned that this is a step in backwards, in going back to the old way where you have overlapping and multiple avenues of recourse for an employee or a union that the employer is going to have to deal with. And in particular, my division, which represents the departments and the state, and unlike DHERD, we also represent the judiciary and the legislature. This will be a significant drain on us if we have to go back to the old ways of defending on multiple fronts. And I agree with prior testimony that this is just unnecessary. We routinely handle complaints by employees concerning hostile work environment and abusive coworkers or supervisors.
Okay, thank you very much. Anyone else wishing to testify on HB 272? Okay, seeing none. Members, questions? Seeing none, Director Krieg, would you mind coming back up? So, with the caveats about your jurisdiction, when a public employer and a public employee in a workplace bullying situation is, what can they do? What can they do, and what are the the administrator or the supervisor of that employee is supposed to do?
If there's any situation where an employee believes he or she is being treated in anything less than a respectful professional manner, the employee always has recourse of raising a complaint within the personnel department of with the personnel staff of the department. There are.
Is that a grievance, or is that separate from the?
That's separate from grievance.
Okay.
They also have the opportunity to go to the union and to initiate a grievance. Depending on the nature of the concern and that the employee has, if it's on the abuse or perceived abuse or bullying, a problem based on a protected characteristic, the equal employment opportunity characteristics. There are also the avenues of going to either designated staff within the departments, or more recently we now have at DHERD a centralized office for equal employment opportunity, EEO. And as a last recourse, if there's nobody within the department employee feels comfortable complaining to, they can approach the centralized EEO office and be heard that way. If it's an EEO claim, they also can go to the Hawaii Civil Rights Commission or the Equal Employment Opportunity Commission. There usually are within the departments separate, specialized policies for workplace violence situations. So employees have the opportunity also to raise a complaint based on a workplace violence policy, and that is usually done internally within the department as well.
So in terms of the complaint or the grievance, is there a definition somewhere of bullying?
No, not that I'm aware of.
What would that potentially fall under in terms of a specific complaint, or do you need a specific complaint?
Well, I don't think that you would. I mean, any inappropriate conduct is inappropriate conduct.
Is there a definition of inappropriate conduct somewhere?
No, if an employee is concerned at the way he or she is being treated. So
then how do you square that with, how does the supervisor or whoever gets the complaint, how do they square that with, you got to have some basis somewhere in rule, law, statute, constitution, or something that says that whatever's happening to you is something that they're not allowed to do.
Most often, in terms of what I think most people think of as bullying or abuse, most often that falls within the workplace violence policies.
Even if there's no physical violence?
Right.
So how does it, what's the standard then?
With all due respect, when you say standard, obviously that sounds like a legal determination.
Well,
And
I mean,
if an
okay, I didn't really mean it as illegal, but what do you, okay, this happened to you, and what says that this isn't supposed to happen to you? I guess that's my concern.
It could be workplace violence policies. It could be an EEO policy.
Okay,
Even if
let's say there's no physical violence and it's not a protected class. It's just a guy being a jerk and,
Okay, that is a typical, interpersonal relationships that come up in the workplace. Even without a definition and even without a standard, there are instances where employees will complain or supervisors will complain. And those issues are typically addressed by personnel staff, because the bottom line is that you want employees who are comfortable working together, who feel that they are being supported and will work together. So if there is a situation like that, regardless of whether it's raised about in reference to a policy or a standard or a definition, personnel staff typically getting involved, or it's supervisors, managers higher up, they will look at it and see, is there some impediment to having this group work together, whatever you want to call it? And if so, what can be done to take that out of the workplace?
That's a good question. So what can be done? So you determine that, you say, well, we're tired of this person making remarks or to a colleague, which is making the colleague feel uncomfortable, and we want to get rid of him. Well, he hasn't responded to any of the things that we've said to him to this point. What basis? Is there any basis for firing somebody who acts in that way?
Not if people are just bothered by them, no.
So if that person knows that, then they can just keep on doing whatever they're doing and know that there's no...
They're just being annoying?
Yeah.
Sure. Right. But,
well, I mean, I think bullying is probably a little beyond being annoying. It is annoying, but it's...
Bullying, no, but I think we're talking about different things here. If it is something, I think what we all think of in bullying is something that goes beyond the norm and is not right, either because there's bad language or because somebody is not being treated with respect.
Okay, so then the simple question is, can somebody be fired for bullying?
It would depend on what else was going on and in what all of the standards are.
Okay. All right.
Okay. I doubt very much.
Hang on a second. Go ahead. Go ahead, Director.
Sorry.
You doubt very much.
What do you mean by bullying? I mean, if something is rising to the level that it is so severe that a person should be terminated, that has to be something that violates some other standard.
Well, that's my point, and I'm not sure that it doesn't seem to me like there is a standard, but I can still see a situation where someone is just obnoxious to their fellow employees, and they won't quit after being asked or being talked to or being counseled or having explained to them that their behavior is beyond the sort of normal interactions humans have in workplaces. But if there's no standard if there's no standard at some point where the bullying can be stopped, and if they refuse to stop, you can be fired, and it seems to me like it's all sort of toothless. And that's the ultimate, I mean, in the workplace, that's the ultimate penalty, essentially, is you get fired.
Right, but keep in mind, we're also working with collective bargaining agreements that have certain definitions and certain expectations and certain standards, right? So unless you were to put in definitions that are understood by all, and that these are standards by which somebody is going to be judged, and if you don't meet these standards, you're going to be terminated, I don't see how that would work.
That's my point exactly. Okay, thank you. Would you like to come back? You had something to say, too? I'm happy to hear.
Yeah. You asked about if somebody could get fired after they don't respond to counseling or directive or whatever. In our division, that's what we do on a daily basis. We take calls from departments about that kind of problem, and we help them through that. It's real simple. The boss of the offending employee gives them directives, either performance directives or behavior directives. Failure to follow those directives is insubordination, and they can be fired. And we do defend those managers who make those decisions. That's what my division does. We go into that arbitration I think Director Krieg is right. We have to be mindful of the collective bargaining requirements. We have to have just cause to fire somebody if they're covered by a union agreement. What just cause can be, the person's insubordinate, they've been given an opportunity to correct their behavior, they haven't done it. The other recourse is to have it reflected in their performance evaluation, because people can be held to a standard of being a good coworker. And we also have recourse under the collective bargaining agreement and through administrative matters of putting the stuff in evaluations, and if there's a dispute over the evaluation, that also can go to something that's called the performance judge under the contract, where that evaluation can be reviewed. So I wouldn't agree that it's toothless. I would say that what we end up doing is we handle it through a management side instead of a statute. I agree with Director Krieg. I think we'd have problems relying upon this statute to take disciplinary action. I think I'd much rather take a management approach, and that's part of what my testimony was, the written testimony was. This is going to undermine department heads' ability to manage their departments, because it's what it calls for is yet another agency, outside agency, to come in and look at their stuff.
Understood. Thank you.
I can just do one follow-up, please.
Sure.
Certainly, the Attorney General's office may see these claims. By and large, we are not, as an employer, any different from private employers. This is an issue that, for whatever reason, has been addressed in the form of a proposed bill that only addresses public employment. The vast majority of our employees are professional. They treat each other with respect. The issues that I think are raised to legislators, as in many areas, are the issues that are the anomalies, or that the minority of employees are experiencing.
Well, I agree with that. But the anomaly is that people don't kill each other too, and we still have laws against murder. So, but thank you. I appreciate your testimony. And members, any other questions? Okay, seeing none, let's go ahead and move on to the next bill, which is HB 400. Establishes a preference for allowing a child who has been or is at risk of being abused to remain in the family home if it's more likely than not that the child would be safe from harm in the family home. First up, we have Director McManaman, DHS. Let's see, which is in support or opposed or? Supports the intent, okay. Next we have Marilyn Yamamoto. Comments only. Next we have Department of the Attorney General, David Louie or Jay Goss. Afternoon.
Good afternoon, Chair Rhodes, members of the committee. My name is Jay Goss. I'm a Deputy Attorney General. I work in the Family Law Division, and we work with the statute every day. As I understand this bill, it's a good intent to have children remain in the home if that's possible. Our problem with this legislation is under the current statute, there's already a test for when a child remains in the home, and that test is the family home is safe with the assistance of a service plan. So in other words, the home doesn't have to be safe and everybody walk away. Under the current statute, as long as a parent is willing to do services and services are available that makes that home safe, the child can go home. Under the test that's proposed in this legislation, it's unclear whether that additional ability to make the home safe with services is present, because the way the bill proposes the legislation is that that just the home is more likely than not the home is safe. There's no mention about the home being safe with services. In addition, our problem with this is it creates two different tests within the same statute of when a child should go home. So on the one hand, you have a judge who's looking at this case and saying, this child can go home because there's services, and then there's another test that just says this child can go home if the home is safe. Now, which test does the judge apply? Because it's unclear, which one they should apply. The preference of our office would be just to leave the statute as is with the current definition, because One, this statute has been in effect for almost 20 years, over 20 years. The current definition of family supervision of when a child remains in the home is also consistent with the definitions of when a child remains out of the home and also when parental rights are terminated. So it makes the statute work better because everything is kind of related to the same terminology. So that would be our recommendation, just to leave the statute as is.
Thanks very much. That's all the written testimony on HB 400 we have. Anyone else wish to testify on HB 400? Seeing none, members, questions? Okay, I don't have any either. Let's go ahead and move on to the next bill, which is HB 420, which proposes an amendment to the Hawaii State Constitution to require disclosure of the names of judicial nominees. First up, we have Judicial Selection Committee, Doris Ching.
I stand by our testimony, which is informational. We need the support proposed for information.
Okay, good comments. Thank you. That looks like the only written testimony. Anyone else wishing to testify on HB 420? Please. Afternoon.
Afternoon, Chair Rhodes, members of the committee. I'm Janet Mason from the League of Women Voters. I'm presenting testimony prepared by Jean Aoki. The League strongly supports this bill. We've had a long-term interest in judicial selection. And when we did our study of this matter in 2002 and 2003, we did a judiciary study, and we focused a lot of attention on the Judicial Selection Commission, because at that time, the public really had no or little input in the selection of our judges and justices, in contrast to states where the public actually elected judges. While we would oppose any attempt to select the members of our courts by election, we did believe, and we still take the position, that the nominees for seats on the court should be released by the Judicial Selection Commission. This would allow members of the public input on the people who have been nominated so that they could comment on their qualifications, just as the voluntary release of the names of nominees started by then Governor Lingle and Chief Justice Moon made possible comments from the public. It was welcome news when the chair of the Judicial Selection Commission did this. We think increased sunshine in the process of selecting judges would really improve the public's confidence in the judiciary. And thanks for the opportunity to testify.
Okay, thank you very much. Anyone else wishing to testify on HB 420? Afternoon.
Good afternoon, Chair Rhodes and members of the committee. I apologize, but we did submit written testimony, and I have copies of them here if you don't already have them.
Okay, thank you.
The Attorney General opposes passage of this measure, but believes that it does present an opportunity for the issue to be addressed and fully aired in terms of whether and to what extent disclosure of the names has any adverse effect on the number of attorneys and the experience levels, composition, or I don't want to say quality, because that would assume that there are those who would apply for a judgeship that are not qualified to serve as judges. But the Attorney General believes that confidentiality has always been something that assures the public that interested people, qualified people, take the opportunity to put themselves before the Judicial Selection Committee to be commissioned, to be vetted. But that there is anecdotal information that we are privy to, that lawyers in the community are aware of, that Justice Hilo and Attorney Case spoke of in the 2 newspaper articles that are attached to our testimony that indicate that there is a dampening, if not chilling effect on attorneys because attorneys have suffered unfair treatment because members of their firm have discovered that they have applied for a judgeship.
Understood. Thank you very much. Anyone else wishing to testify on HB 420? Okay, seeing none. Members, questions? I have a question for Chair Ching, if she's... Oh, there you are. So just for clarification's sake, what's the current, what is currently the practice now? Is it all, my understanding is you guys get a bunch of names sort of over the transom, you whittle it down to 3 or 5 or whatever it is, and then you submit those to the governor. What do you do now? Do you make public all the people who applied, or just the ones that you're passing on up?
We just disclose those who are nominated by the commission and sent to either the Chief Justice or the governor.
So just because you've expressed interest in it doesn't mean that in fact your name would not be revealed at this point?
That's correct, at this point, yes.
Okay, thank you very much. Ms. Mason, can you come back up? And the League of Women Voters position is that all the names should be revealed, or just the ones that are picked by the selection commission and then sent to the governor?
Just the names that are selected by the Judicial Selection Commission and sent to the governor.
So you're okay with the other people who've thrown their hat in the ring?
Yes.
Okay.
Yes, but we strongly think the public has an interest in knowing which names were sent to the governor.
Okay. All right. Thank you very much. Members, any other questions? Seeing none, I think that's the last item on the agenda. Yep. Okay, so for all the bills on this agenda, I will be deferring decision-making until this coming Thursday, the 23rd, at 2 p.m. in this room, 325. So all the items on this agenda, decision-making will be on Thursday, January 23, 2 p.m. in this room. Thank you very much for attending. Have a pleasant weekend.